So without further ado, I'm Camille. I am the patent attorney at Wilson Dutra, and I guess I've been here from the start. And yeah, so now introducing Fernando.
Hi, I'm Fernando Dutra. For those that don't know me, I am a trademark attorney here at Wilson Dutra, which is basically the branding side of what we do. Camille is on the invention side, and we both work on any contracts that touch on branding or inventions. So to get started, as Camille mentioned, is the overview of what is intellectual property. We thought this would be a good start for any town hall because we're going to get into the weeds very quickly about some of the initiatives, and it's great to have everyone have at least an equal understanding of the different types of intellectual property, starting with patents.
Yeah, so patents protect inventions, and that could include a process, a product, software, ways to manufacture something, anything along those lines. Patents are unique because they don't give you the right to do something. They give you the right to exclude people from doing it. It's basically a temporary monopoly for 15 to 20 years, which for some technologies, that's quite a bit of time. And another unique aspect of patents is that the only way you get protection is by filing with the Patent Trademark Office and having them issue that patent. You get no protection prior to that. And some common examples of patents, some of them are in here. BB-8, I don't know if anyone's a Star Wars fan, but BB-8, which is the little orange guy here, they actually got a patent on it because he's a functional prop for the movies. So you see him spinning and his little head stays on top. That was actually patented. And then you can see the little Amazon snippet here. That is because they got protection on the one-click. Interestingly enough, as soon as it expired, which I think it was a few years ago, they changed it to some other dynamic, like some other functionality. Another thing that's included there is pharmaceuticals. That's an easy one to know when their patent expires because it's the day you see generics come through. You know, you have to pay for the name brand for 20 years exactly, and then the generics come out. And you can kind of see the name brands trying to extend their protection by getting like, you know, extended release versions or separate kind of iterations on their own original. So that brings us to the next type of intellectual property, the next two, and really something to keep in mind as we go through these. There's a lot of overlap. So almost every company has at least 2 or 3 of these. It's a matter of being able to identify it. So I pass it off to Fernando.
Hello. So the next type of intellectual property that we're going to talk about is trademarks, which is really a reference to a company's branding. And it could be any number of things. It could be the words, it could be a symbol, it could be a slogan, it could be a design. Really creative companies can sometimes trademark a color if they're known for it, or a sound. So the coin sound in like Super Mario that you hear when he hits the box, that's a trademark sound now. For color, like the insulation filling that's pink that you see is a trademark color. They became known as the brand that has the pink insulation and filed for protection on that. So the important thing to know, what's that?
UPS has the brown. I don't know why someone would pick brown as their color, but.
They're very proud of that brown. But the thing to note for trademarks and branding is consumer confusion. So trademarks, you file for trademark when you kind of see yourself as the source of a good. You become known for a certain quality or a certain type of good in the market. So for example, whenever you see a swoosh, there's a certain expectation that comes with purchasing a product from that company, Nike, right? I can expect the shoes to be of a certain quality. I can expect them to last a certain amount of time based on that name recognition and the quality of that company. Now, if we see a swoosh on a carton of milk, which is our go-to example here, people might think that Nike has entered into milk business, right? Like, oh yeah, that's a natural expansion of their powers, right? Because Nike is everywhere. So you're always looking, yeah, right. The gator milk. You're always looking for potential for consumer confusion. And the height of any trademark is reaching that level where you're so famous that you could potentially cross into any market. But when you start in the process, you file on a very specific category or class that you start with, and then you kind of build your brand from there. So an important thing to think about when you file for a trademark for your branding is to think about where you are now and where you might go. So the biggest thing when you're just getting started is to make sure you're using your branding consistently. If you're doing different iterations of your name, you're adding letters, numbers, anything like that, you might want to think about paring that back and thinking through, how am I actually using this? How am I actually selling this on a product? How is my consumer coming to know me? And using that as kind of your starting point on your branding. Unlike patents, you do not have to file immediately to get trademark protection. It kind of grows organically over time, but you're limited to the space where you are, right? Whether that be industry or geographically. So old times, way back when, this would be for restaurants, right? Because you normally open a restaurant, you might not be thinking of expanding or franchising yet, and you're limited to your area. Right? In Jacksonville, Florida, everyone goes to, we'll just say Firehouse Subs when they started, and they weren't known nationally, right? So Firehouse never filed on a trademark, using them as an example because they're local. They might have been limited to Jacksonville, right? But then if another Firehouse Subs came into Jacksonville, Firehouse would be able to come in and say, hey, actually, we've been here before you, and we've been using this name, and we're known in the community, so we can ask you to not grow into this market or change your name in this market, right? So the power of a trademark is, and we'll get to this later in the slides, so spoilers, is thinking through how expanded just the general nature of commerce is now, right? When you launch, are you, by just the essence of having a website, now national, right? And since that's sort of the case now, you might want to look and expand on your name when you get started. So always just do a search before you fall in love with the name, because we've heard so many heartbreaking stories of companies who just love their name, and there's, a quick Google search for 5 minutes would show that there's someone in their space or in that area or with a similar name. So that's branding. The next form of intellectual property is copyright. So copyright refers to creative works that are fixed to a tangible medium, right? So if you just danced somewhere just for fun, as people do, that would not be protected, right? If you, what we tend to do is, normally when we give this talk, we kind of just put it out into the ether, and it's not recorded or filmed in any way. It can't be copywritten. Right now, we are recording this talk on Zoom, so there's a potential for copyright here, that this information that we're giving can be filed on and protected in some way. So common examples of copyright include creative works, songs, albums, films, screenplays. It's expanded recently to also include software code, which is now basically treated like literature. So it's an expansion of those rights. I'm sure that people who were writing code for so long were like, yes, this is my novel here. This is my Dickens, or my Jane Austen novel that I've written in code. So Camille, would you like to talk about trade secrets? Oh. Because of muting. There you go.
Hi, sorry, I had to go on mute because of course, you know, Murphy's Law. There are tons of noises around me all of a sudden. So I apologize if that's happening. So last but not least, trade secret. I'm touching on, between patents and trade secrets, I'm touching on kind of the extremes of what you have to do to earn protection. Trade secret is only powerful because it's secret. So the only reason something has value is because it's secret. The classic example is the Coca-Cola recipe, right? You might know the ingredients. You might know, even like by the order of ingredients, you might know how much of each one's in there, but still to create the actual end product, who knows what happens in between, right? You know, certain parts of it might have to go up to 150 degrees. I don't know. No one knows, clearly. People can try and copy it, but they can't actually get the exact same product. And so partly why that's lasted so long is because you can't reverse engineer a recipe, right? You can reverse engineer the ingredients, maybe portions of it, but it's really tough to reverse engineer a recipe. In contrast, let's say it's a product like a car. Someone can reverse engineer a car. Someone can reverse engineer most software. So those things aren't protected by trade secret, even if a company would like some of those to be trade secret, it can't be if it's publicly available and reverse engineerable. A place where I used to work, they had a lot of things that they thought were trade secret. They gave, they're like, oh, this equipment, we're not doing patent protection, it's trade secret. And everyone's like, oh, that's a great idea. But then they gave tours of those pieces of equipment, which negates any potential for trade secret protection. So because the value is in its secrecy, there have to be a lot of things in place with the company related to that information to elevate it to that level for trade secret. Like the term confidential is not enough. So, you know, there's a lot of confidential information exchanged at companies, between companies. That does not necessarily mean they're trade secret. For instance, if you might have a confidential employee handbook. If your handbook goes to all your employees, that is not trade secret. Most of the time, the easy ways to kind of check the box is no one person has the entire information. So you might have, you know, a portion of people do like an assembly line type recipe. Trade secret is often taken for granted. I would say that almost every company has a trade secret, and usually, like for instance, every company has a client base. They have a client list, they have a customer list, you know, they have internal kind of marketing goals and kind of targets. Typically, very few people in a company would know the entire view of that. And that is quite valuable as a trade secret. Like when you sell the company, a lot of times what you're giving them is your book of business, your client list. So that is something that is commonly trade secret for most companies. Again, kind of going to the point for overlap, a few things that like someone can get a patent on, for instance, we have I can't point, but the little, the smartphone icon. Someone can get a patent on the phone itself, for instance. They could do the software behind it. They could get a trademark for the app or the company, right? So Apple, right? That's a brand. The copyright would be the code behind it. And the trade secret for software tends to be algorithms. Algorithms are, you know, very protected within companies. You might know that this software brings you from point A to point B. Who knows what happens in between here? It's like the magic that happens. And that's another common trade secret for companies, particularly software companies.
And Casey points out, one of our people in the chat pointed out that the actual and the birthday girl pointed out that the process for Shark Tank, like how they decide on an applicant, what their, however you go through it, is a trade secret. You sign an NDA not to talk about how they actually make their decisions. So that's an overview of intellectual property as a whole.
It was a very,
we can touch on any
overview.
Now you're all experts on intellectual property.
We're experts.
So
you don't need us. We're good.
at the end of this, there will be a quiz where we follow up. But something that we wanted to touch on are the incentives or the programs that the United States Patent and Trademark Office are doing now as a result of COVID-19. So we have a little bit of an overview here that Camille can start talking about. And we're going to also show you one of the resources they have in case you wanted to look into it after this talk. But at a very basic level, they're moving things to be more remote. So the offices are shut down. You can't actually go there. They're based out of Alexandria, Virginia. So you can't go there in person and have an in-person interview with an examiner or drop off paper filings anymore. You have to mail those. And they also made a big push to encourage electronic filings.
Yeah, just full disclosure, I'm not sure why people show up to their office anyhow. Most people are remote, and they incentivize electronic filing by like doubling the price if you do it otherwise. So this is almost like they were just waiting for an excuse.
Right. And a lot of the information's on a month-to-month basis. So they change and they extend a lot of these programs within days of the end of the month, right? So right now we're noting that there are a lot of deadlines that are coming up on July 1st as of this presentation. In 2 days, this might change. But before this, there were deadlines extended to June 1st, 2020. So it's been a matter of, in the last 2 days of the month, they make a decision of whether or not to extend leniency on deadlines. So Camille, was there anything you wanted to touch on in this list before showing the resource center?
So one thing to note, because their deadlines and their response has been changing and like evolving, there are a few things to note. You could just act in abundance of caution and pretend that those extensions don't exist and then get lucky when you do. For instance, if let's say you have a known deadline, you might get surprised and not have to pay extra fees. But it's best not to push it beyond what would typically cause an abandonment of your trademark or patent. So for instance, there are hard deadlines so that if you don't do something by a deadline, then you lose any rights to that patent or trademark. Despite all these kind of leniency and allowances and extensions, we do not recommend going past that. If there's a way to, there's an ability to extend time just by paying more money, Patent and Trademark Office loves money, then go ahead and do that, but don't rely on it to protect you from abandonment. Despite them saying you can, one of those things you don't want to play with.
Right. We still don't, because of everything that's happening, we still don't know what will happen if something does go abandoned and then you revive it, you bring it back in a 1 week gap, 2 week gap. We don't know what will happen yet. Right? Will they treat it as if everything that came after you suddenly can be used against you? We don't know that yet. Or if it's just, a pure, it's okay, we're waiving the revival fee for you and you're back to the way you were. We still don't know what they're doing with that. So this is the COVID-19 Resource Center that the USPTO launched. This is constantly updated with the latest information that they have going on. So there's the patent side and there's the trademark side. They talk about international a little bit and how things are being affected there. But this is kind of the go-to resource for staying up to date on any of their initiatives. And we're going to go into two of them now, one of which was just announced last week. But on the patent side, the invention side, and on the trademark side, the branding side, they've launched kind of sister programs that are targeted at solutions for COVID-19, helping inventors and people who create products that have branding around COVID-19 and solving that issue to get them through the process faster. So we're going to share this link in the chat for anyone who's interested in learning more about that. But we will move back to our PowerPoint for now.
Okay. So for the patent side, they're really trying to incentivize small and micro entities. And for those of you who are either new to the patent process or, that's not really part of your business, small and micro entities are what you would consider small businesses, and individual inventors. Like micro entity is based on income and like revenue. Small just means you have like under 500 people in your team. So it's a pretty large number, but just like the Fortune 100 or whatever, they're all going to be excluded from this opportunity. And what they do is they are allowing for free prioritized examination for up to 500 applications without requiring the fees. For reference, to normally do an expedited, it will cost an additional $1,000 or $2,000 per application. And you never know when they get, because it sounds like a really small number. And one of the concerns is, well, how fast will they go? Look at the June 18th. The June 18th one, I think, had been around for almost a month or a few weeks by that time. Only 35 applications had gone through. Something there.
So just to chime in with more updates on that, just because it's something we're monitoring and we have, this brand new, so it's very interesting to us. But as of this June 18th date, 122 people filed for this program, 35 were granted. So statistically, 1 out of every 4 get in.
And we don't know if granted versus, pending. We don't know if that means the rest were rejected or the rest are just getting reviewed. So there's, it's fun to have mystery. We are watching it carefully. We actually have some clients that are trying to pursue this. So it will be interesting to see how it develops over time. Right now, they are not like when you call the Patent and Trademark Office, it's just like anything else. You don't know if you're going to get someone really well qualified to answer the question or not. So the kind of the criteria to be part of this pilot program is to, as you can see here, it's listed out, at least one. So claims define the scope of your protection, and it has to relate somehow to COVID. And it has to be subject to FDA approval. Now, what that means exactly, I guess we will find out when we submit the current application that we have. But we don't know if it has to be like directly related to COVID. For instance, does it have to directly relate to, you'll see this with the trademark side. Does it directly have to relate to treatments, or could it be, COVID causes this commonly, like these are the common symptoms of COVID, and our solution addresses that secondary issue? We don't know. And subject to FDA approval could mean, there's a wide range of products that go through the FDA, from, what you'd expect, like like things that are used at the hospital or medication, which is a long process, versus I think even like a toothbrush or something. There are some like really surprisingly low risk things that have to go through FDA. And they haven't there's no qualitative aspect of it quite yet, like how much it has to relate to COVID or how much it's subjected to FDA. But that's kind of where we are. Again, only applies to, I think, utility and plant patents. There's the quick overview there. We didn't touch on it. There are three main types of patents: utility, design, and plant patents. Utility protects functionality. Design protects aesthetics, like how something looks. And then the plant patent protects exactly what it says, a plant. So apparently the design aspect will not be eligible for this program. As a note also, when they say accelerated, they don't specify the turnaround. Typically a patent to get reviewed for the first time can take anywhere from a year to 3 or 4 years. If it's like other expedited options, like if you pay for it or if you happen to be over 65, they do get seen within a few months to at least under a year. So that's a pretty big dent as far as cutting down on the time it takes to get to a decision about your patent. I think that kind of covers the patent side. And as Fernanda said, there's a sister program for the trademark side that they just released.
So fresh off the presses, we have breaking news on this town hall. They just announced this last week, and this program went live on June 16th. So it's barely a week old, but the trademark side of things has a sister program like the patent side, and it's very similar. But because of the nature of trademarks and branding, when you file, you choose a specific class to file in, basically what industry you're in, and this streamlines that process even more. If you're in 2 particular industries or you're thinking about filing in 2 industries, there's an opportunity to file for a prioritized examination in the trademark world. And those are basically pharmaceutical products, medical devices related to the treatment of COVID-19. So if you fall within that scope, there's an opportunity there to file a prioritized trademark examination. Given that the trademark process takes about a year, generally, we have no idea how fast this prioritized examination would be. We imagine it would be, in 3 months, you'll probably go from filing to getting something back from an examiner. So the classes, because this is so new, the classes that they're talking about for this are pharmaceutical products or medical devices, such as diagnostic tests, ventilators, personal protective equipment, including surgical masks, face shields, gowns, gloves that prevent, diagnose, treat, or cure COVID-19. That is also subject, huh?
I love the cure
Sure.
one. I hope someone files on a trademark to cure COVID.
But for this class, for these products, it has to be subject to FDA approval. And then alternatively, if there's medical services or medical research services for the prevention, diagnosis, treatment, or cure of COVID-19, that's also a candidate for a prioritized examination. So basically, trying to help businesses that are branding themselves as working on the solutions for COVID, they're trying to incentivize them to file for trademark protection as well and get that kind of name protected for them, and start generating that goodwill and that recognition earlier. So our final slide here is just about, might be more relevant of what we're seeing as a result of COVID-19. How has COVID-19 affected inventions and branding as a whole?
Practical level.
Yeah. What can we expect now post-COVID-19 as we adapt to this new normal, right? Camille, I don't know if you want to start, if you want me to jump in.
Yeah, so since the first one relates to the invention side, and we've actually seen this like firsthand, and you would be shocked how quickly we saw this. There's been an increase in innovations related to really anything that has come up in quarantine or and like social distancing, things like that. I mean, I think it was actually already like the second or third week in March that we started getting calls about technology related to this. So people, I mean, was it necessity is the mother of invention? And people saw necessity and then they kind of solved these problems. Um, what's really interesting here is although the concept of being germ free or hygiene has been around forever. Well, that's not true. I'd say it's been around for almost a century. Um, it was never the forefront of our society. I think in other societies it might have been more prevalent, but here it really hasn't been something that's been really important. So even though it's an old problem, the amount of innovation that's come since March has been like astonishing. Um, and like I say here, they're huge range from the simplest thing to like a new type of mask, or there are things called like ear savers, where you hook your mask to these to avoid using it around your ears. Um, I know someone that has a modified version that um, puts it low enough where you can get a haircut. I mean, so like everyone's coming up with solutions for all these problems. Um, and simple products are like really simple products are still really innovative still because it's like this new focus on this old problem. Um, and I'll go to Fernando and kind of bring it up at the end on what that means and what opportunities that brings for inventors and companies.
Right. One thing that we're seeing on the branding side of things is there's now a shift just naturally as a result of the pandemic of everyone moving to online retail and not leaving their houses as a result of quarantine in certain markets, and ordering everything online. As a small business owner, that means that you have more than likely shifted to meet the needs and the demands of your actual buying public, right? So that brings an increased attention on the branding side of things of, are you federal immediately when you get a website? When you open your doors and you're selling to people online, regardless of where they're purchasing from, typically when you file for federal trademark protection, that means that you have some form of interstate commerce. Just by the nature of starting a website, is it more likely now in this environment that someone in Wisconsin on the other side of the United States that you never imagined might be someone purchasing your product is now someone who has more time, they're online, they're searching for new products or solutions to some things that they're handling now, going to come across your website and start ordering from you, right? Are you expanding your advertising into different markets that you've never advertised in before, which raises the importance of your brand and doing a little bit more due diligence as you get started to make sure that, maybe there was this company that I've never heard of before that's in our same space that we never would have intersected before COVID-19. That now increases that, ironically, that potential for collision, right? We normally think of collisions in a local sense, right? You go downtown, you see someone you haven't seen in a long time and you catch up. That's now shifting to an online space, right? So that's just something to think about as COVID-19 continues when you're launching your brand. Even just doing that we mentioned in the beginning, that 5-minute Google search, just to see if there's anyone else out there. And one thing, and this will tie in, segue with Camille, is there's almost a gold rush to fill the needs that have come up as a result of COVID. So there are potential markets that small businesses are pivoting to as a result of increased demand or need from their customers that they otherwise would never have thought of before. So on the branding side of things, you might not have ever thought about filing for trademark protection in a certain area, right? Like something like a sanitizing product that now you're selling because you have the capacity to do so, or you have customers who are asking whether you're going to sell it, and you start to, right? There's an opportunity there, and you're catering to the needs of your asking public. Maybe you go ahead and you prepare a trademark application in that new space because it's possible that other people have not filed in that area yet, and it's a growing commercial opportunity for you, right? And then on the patent side of things,
yeah, so the patent side and even the branding side kind of ties together there, because kind of, I mentioned that, there's this rush to now fix this problem that's been there forever, but it's at the forefront now. Something that used to be, a lot of times solutions and market shares are dictated just by funds, right? You get, a little company goes against a big company in marketing. The big company will probably win just because they have so much more money. The benefit of small businesses right now that they get is that they're agile. I don't know if anybody else started buying masks, but it took, the first wave of masks that I saw advertised, let's say through Facebook or anything like that, were all small companies. Big companies did not come out with them. Maybe some of them have it now, but the ones that have it now are still like these, like really boring, straightforward masks. They're just kind of like functional. And I'm pretty sure they're just hopping on the train because they're like, oh my God, all these small companies are snatching up the market space, which is really interesting. Because it's a unique, by quarantine, a lot of times they had to shut down. A lot of the companies had to shut down either from layoffs or layoffs and manufacturing restrictions, things like that. And smaller companies that could persevere through that, bounce back and were like, okay, we're going to pivot. We can do this. We're going to sell masks. And it leads to some new opportunities. And there are things that you can do to protect yourself to really leverage it. If you're coming up with a new product, a small company or an inventor can file a patent application probably more quickly than a large company, even though they have tons of money behind it. There's a bureaucracy there that small companies just don't have. And then on top of that, small companies that are now into this new space of, let's say, masks or sanitizers. I don't know if you noticed, a lot of distilleries now sell sanitizer because they had their manufacturing was easy enough to pivot where they probably weren't selling as much alcohol because they couldn't bring people to their store, but then they could serve this other need. And a lot of them started off just selling, to manufacture them and give them away. But there's no reason why they can't continue to sell that. And then they get to pivot into this new market. And if they start filing trademarks in those areas, then they suddenly have a presence in this new market. And sanitizers and masks were not an intuitive market expansion plan for, I don't think I can't think of a single company where they're like, first month we're selling pants, next month we're selling mask, guys, unless it was under this situation, right? This is a weird, unique moment, I think, in our history. At least I hope it's unique. And the small businesses have really stepped up. And I think there's a lot of opportunity now that people can take advantage of. At least explore. I think small businesses at least need to explore their options with filing, expanding, pivoting, and then you can make a decision not to, but at least give yourself that opportunity. So I think our next bit is questions and answers. I think we have like 10 minutes if anybody has any questions to go through here. I think we threw a lot at everybody. So as you process it, you may have follow-up questions. Like in the middle of the night, you're like, oh my gosh, I now have a question. You can email us, call us. That's actually my direct line, so you can call me. You can check out our website, and there's a contact form through there. Between the three options, I would recommend either emailing us or calling us.